You are unmuted.
All right.
Someone make it make sense.
Probably a couple.
So the charge conference, the first.
All right, y'all, we are here. We are here with jury instructions, fast and furious. I updated my thumbnails, created this PM stream. For anyone who's just going to be joining us here now, we did an earlier stream for the AM with the final defense witnesses, and they also rested their case in chief. And then it was kind of touch and go whether or not there was going to be another stream because all the court feeds cut. Anyway, we're back here in the afternoon for jury instructions, and tomorrow we will begin closing arguments. So, quick note, if you ever hear her mention the charge, jury instructions is also called the charge. It just depends on your jurisdiction, depends on the court. They're synonymous. So whenever you hear her say the charge, if that's an unfamiliar term to you, those are the jury instructions. So what's going to happen now is there's no jury present. They're outside the presence of the jury. This is the attorneys and the judge essentially arguing over the jury instructions. Hi, Candace, happy to see you. And they are going to figure out, this is important. This is really important because this is what will be given to the jury for them to determine and come to their verdict. This is in every trial, jury instructions are crucial. The languaging used, it's going to explain the charges, it's going to explain the burden, all that. And this is the last chance for each side to kind of really get into the law in terms of how it should be explained to the jury in a way that makes sense to them. And they're going to argue over the nitty-gritty, I'm sure. So I'm wondering if they'll even finish it this afternoon, but I think that's their goal. So we shall see. All right, so let's jump right on into it. And I have it at normal speed.
This question I have is regarding I'll go through them in the order that I have them in my very rough draft.
Okay.
But
for anyone who saw the trial, the Jay Hatch and Maya Kowalski trial, even though that was civil, one thing that was really interesting there, because there's going to be, that was such a huge trial and there's going to be such a lengthy appellate process expected with that. And there's a lot of, it was really complicated. I don't know if for anyone that saw that, one thing that was really interesting is they started working on jury instructions long before the trial started. And I think every single day during the trial, they discussed jury instructions and they argued over making a change here and a change there and adding this and that. Jury instructions were like an ongoing project that they worked on every single day because they were looking that far ahead. Like with everything that happened during the trial, for each ruling, for each objection, for each whatever, it's like, all right, let's update these jury instructions. And then of course, at the end of the testimony, they still had to, I think they spent several whole days on the jury instructions for that trial. So anyway, it's just interesting to note.
there's no request of the lesser included offense of voluntary manslaughter to the second degree murder charge. Is that what the Commonwealth's intention is, not to request an instruction on voluntary manslaughter as a lesser included of the second degree murder?
I'm sorry. That's correct, Your Honor.
Okay. And neither side has requested an instruction of a lesser included of OUI?
Huh.
It's correct as well.
And the defense is not requesting that?
That's correct, Your Honor.
Okay. All right.
So but that sounds like to me is they are not. They're not including that. So That's very interesting. So the OUI is operating under the influence. So that's the vehicle. So remember how there were like the 3 charges and like there were these other lesser includeds? It sounds like they are just not. If they're not including an instruction for them, I just don't think that they're being put in the final verdict form, right? Like that they're only going to be going off of like what is the second degree murder or not, which is interesting. Huh. I wonder if the Commonwealth is thinking that they would be more likely to get a guilty verdict if the jury only has one option. Huh. Interesting.
All right. So the first instruction, the request from the defense is that I split the charge, and it's written that way. I'm not going to split the charge. So the way it'll be is the defense will argue first, then the Commonwealth, and then I just go through all the instructions. So aside from that, the first instruction is presumption of innocence. I have one that I typically give, but I will give the one that's requested by the defense. Next
So
instruction.
she is saying, so like what I was saying at the end of the last stream, is that, you know, there's different ways it can be done with closing, with the jury instructions. Sometimes they're read before closing arguments. Sometimes they're split in half. Sometimes they're done after. She's saying she wants to read the jury instructions after closing arguments. I'm going to back that up one more time just to make sure I heard that right. But that's what it sounds like, which I don't prefer, and I'll tell you why. I feel like it's better for the jury to hear to have the jury instructions first, because oftentimes what you'll have is in closing arguments, it's a really good tool for the attorneys to use. And they will, and we saw this in Murdoch, we've seen this in a lot of trials, where they will actually refer back to the jury instructions and they'll say, and they'll walk them through it. It's a really good plan to say, here's the jury instructions. Let's walk you through how we think you should come to whatever our, whatever side we're on, whatever they're arguing, right? Like, here's why it should be guilty, or here's why it should be not guilty, and go through the jury instructions with them using their theory of the case. So I think it's actually, I prefer that. I think it's better for the jury, but it sounds like that's not what she's doing. But let's back it up and just double check, because she's kind of plowing on through.
Typically give, but I will give the one that's requested by the defense. You first, then the Commonwealth, and then I just go through all the instructions. So aside from that, the first instruction is presumption of innocence. I have one that I typically give, but I will give the one that's requested by the defense. Next instruction is our reasonable doubt instruction. Then function of the jury. First instruction is presumption of innocence. I have one that I typically is that I split the charge, and it's written that way. I'm not going to split the charge. So the way it'll be is the defense will argue first, then the Commonwealth, and then I just go through all the instructions. So aside from that, the first instruction is presumption of innocence.
Okay. There you go.
I have one that I typically give, but I will give the one that's requested by the defense. Next instruction is our reasonable doubt instruction. Then function of the jury, the arguments of the lawyers and the judge's comments, function of the judge, functions of the lawyers. Verdict must be based on the evidence. I've incorporated some of what you've both included into that. I have language here that similarly, as you review the exhibits, you may find that some information has been removed because it is not relevant. Please ignore that and don't try and guess what may have been removed or why. I think that came from the defendant's request.
So she's saying that's what's going to be, she's talking about, like, she's not talking to the attorneys, right? She's talking about what the jurors will be reading. So she's saying that part of what, she's just kind of going an overview here, right? It's her rough draft. She's saying that part of what's going to be in there is they're going to say to the jurors, if you see exhibits and there's something that's missing, and I'm sure she's referring to things like being redacted, right? This would be an instruction for the jurors not to try to guess what's been removed. I mean, that's logical.
Any information that you may have read, heard, or seen about the case outside of the courtroom is not evidence. My instructions to you and any comments I made, the lawyer's opening and closing statements, and any comments they may have made are not evidence. Answers that I struck from the record and told you to disregard are not evidence. Only the testimony of the witnesses, that is, their answers to the questions and exhibits, are evidence, with a more robust instruction, but that's what I've added. And I do have a line about sympathy. Then I do the view. I should say right off the bat, I am not going to give a Bowden instruction. You can argue it. You've been able to put in a tremendous amount of evidence. I've given you a lot of leeway with that. But there is something in this case that and I'm fully within the law to do that. So I have here some language that I think is appropriate based on issues that were raised about the credibility of witnesses. Did the witness have
Yeah,
any
wonderful.
bias, reason, or motive to
Yeah,
give false
this is
or
important.
shaded
This
testimony?
is important.
If so, you may consider that bias or motive in your deliberations
Wow.
and ultimately as to whether or not it impacts the credibility of the evidence presented. So I cover the.
Well, there
bias
you go,
part of it.
Lolly. Game over, man. Candace is
And
laughing.
we'll go through and you
Appropriate.
can tell me
Laughing is
who's
appropriate.
going to argue this for
You're
the
fucked, man.
defense.
I want to hear that again because yay. Let's just that is crucial, man.
Bias part of that.
Let's back up a
The
little bit.
credibility of the evidence
Hold on, sorry,
presented.
guys.
Shaded testimony. I have here some language that I think is appropriate based on issues that were raised about the credibility of witnesses. Did the witness have any bias, reason, or motive to give false or shaded testimony?
Wow.
If so, you may consider that bias or motive in your deliberations and ultimately as to whether or not it impacts the credibility of the evidence presented. So I cover the bias part of that. And we'll go through and you can tell me who's going to argue this for the defense. Okay, so we'll go through and we'll do each one. The limiting instructions, I give the defendant's bad acts instruction. I'll give a similar instruction on the digital evidence that I did during the trial, photographs and testimony with an emotional impact, humane practice, and as of today, hypothetical. I had hoped that both of you could suggest something. I said that this morning. Do either side have anything for me on hypotheticals?
Hypotheticals. Okay, I was just going to say real quick that just because Yannetti is going to be arguing for the defense does not mean he's going to be doing closing arguments. It could just be because he knows the law in Massachusetts better than Alan Jackson, who's from California, I believe still lives there. And also, I forgot to mention, she did this registered, but it happened so fast. So it sounds like she's going to have the defense argue first in closing and then the prosecution. Normally what we see, or rather the Commonwealth, usually what we see is we see prosecution, defense, prosecution, right? And they go last. It sounds like this is going to be only just the defense is going to go first and then the prosecution is going to go last, which is interesting as well. So yeah, Candace, I know, right? Seeing the defense is the only side that presented non-biased testimony, right? Man.
I'm sorry, I don't, Your Honor. We're going to be getting back at a fairly early hour. I'm happy to work on it.
That's fine. I mean, I can do it, but I wanted to give you both the opportunity. Yeah, go ahead and do one and send it to me.
I'm happy to do that.
I'll have one to you by the end of the day.
Okay, thank you. All right. Opinion testimony, evaluation of exhibits, direct and indirect, and circumstantial evidence. So I received today defendant's request, a late request for the law allows both direct and indirect evidence, and there is no distinction to be given. A conviction, however, may not be based upon the piling of inference upon inference or on conjecture and speculation. I don't think that's exactly the language from the case law here that you've cited. There,
I actually quoted it, Your Honor.
so from which one? From Haunch or?
From Hunch. Hunch quotes McCormick, and McCormick takes the law from Dusty. There are
Yeah, so
multiple cases that
right, and the language that is typically given on this piling that I haven't really seen in years is you should not pile inference upon inference until the pile gets so high that it tips over logically or the chain gets so weak that it doesn't hold together anymore. When you run through your inferences, check the starting point and the ending point to make sure they're still reasonable. I mean, I could give that old language. All right. That's,
prefer that.
all right. I haven't given that in years, but I'll give that part of it.
Cool, I like it.
And just to finish off that paragraph, When the evidence tends equally to give rise to either of two inconsistent propositions, the Commonwealth has established neither proposition. In order to convict the defendant, you must find that all the evidence and reasonable inferences that you have drawn taken together prove that
Yes.
she is guilty beyond a
That's
reasonable doubt.
fucking, okay, hold on.
Okay, so that rounds off that.
So that's important. So what that is saying is that if you've got two things that could both be true, right? Two things that were, could be one thing or the other thing. They have to view things in the light that's most favorable to the defendant. So in the case, I don't think this is going to happen in this case where Lawley had anything that was on par, like equally, right, with like the defense in terms of if it was credible, substantial, you know what I mean? Like we're like, oh, I don't know if it was this or that. Like, but if that happens, they have to view things in the light that's most favorable to the defendant. That's what that says.
All right. All right, so now we'll talk about the indictments and the lesser included. So the second degree murder instruction that was provided
Okay.
by the Commonwealth and the one provided by the defense are just a little bit different. So if you take what was provided, there's one section that the defense incorporates that I think is missing from the instruction, and I'm going by the SJC instructions. So when you get to the second element of second degree murder, the defendant intended to kill John O'Keefe, the second element, first prong. So the second element is that the defendant intended to kill John O'Keefe. As you can see, the second element has three sub-elements. I'm reading from the Commonwealth's proposed instructions, which I shall call prongs, and the Commonwealth satisfies its burden of proof if it proves any one of the three prongs beyond a reasonable doubt. The first prong is that the
So just like how whenever we go over the different like statutes, say, right? Where it's like kind of like there's like a number and then a bunch of letters underneath, right? So that's kind of what this is. So the first element. So she's talking about, this is the biggest charge here, right? Of the second degree murder. Okay. So the first element, this means this is the first thing that has to be met. Now of these prongs, what she's saying is that the jury does not have to find all of them. It only has to find one of the prongs. So my guess is the languaging here is going to be this, and then the word or. So this, or this, or this, or this, blah, blah, right? I don't know how many prongs there are. We'll find out. But it's going to use the word or, and it just means they have to find one of those. They could find more than one, but it just has to have one. And if so, the first element has been met. And then after that, there will be additional elements that have to be met as well for this charge of second degree murder.
Defendant intended to kill. Now here, I am going to insert, because if you go back to the SJC instructions, I think it is appropriate to go back to the instruction on deliberate premeditation, which is the second element of that, is the language that is offered here by the defendant, that the defendant consciously and purposefully intended to cause the death of John O'Keefe. So who's arguing this for the Commonwealth? So Ms. McLaughlin, does that make sense there?
Yes.
Okay, so I am going to put that in there. All right. And the defense has the language of accident there, but Mr. Yannetti, that really goes at the end. That goes, as you'll see if you look at the instruction on extreme atrocity or cruelty, where you have to go. So that'll go at the end. That will go after the third prong definition. Then I will include the language that I think the Commonwealth put in its request. It goes there. If you have a reasonable doubt as to whether the victim's death was accidental because the death was caused by a negligent, careless, or mistaken act of the defendant, or resulted from a cause separate from the defendant's conduct, you may not find that the Commonwealth has proved the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have created a plain and strong likelihood.
All right. So here's what
Then you
that's
have
a big deal.
the,
So that's a big deal. So that's why this matters, because she's being charged. The charge that she has with a second-degree murder is an intentional, like, volitional act, right? And it has to be done with malice. I'm sure she'll get to the malice. So in other words, what she's saying is that if the jurors have decided that it was an accident, that she didn't intend to, but she was nope, sorry, the Commonwealth has not proved their burden, met their burden, no go.
in deciding whether the defendant intended to kill, intended to cause grievous bodily harm, or intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result, you may consider any credible evidence that the defendant suffered from a mental impairment or was affected by her consumption of alcohol or drugs. That goes there.
That's fine, Your Honor. with us.
Okay, does that make sense to you too, Ms. McLaughlin? Okay. All right, do you want both the mental impairment or consumption of alcohol and drugs? Do you want to just leave the whole generic sentence?
I think we can, yes. I think that's
Is there any objection from the Commonwealth on that?
I don't believe there's any evidence of mental impairment, but the Commonwealth has no strong objection.
All right, but there's no evidence of drugs either, so do you want it to just be alcohol?
I suggest that would be most in line with the evidence, just to have intoxication under alcohol.
All right, it makes sense to me, Ms. Giannetti, if we focus just on the alcohol, but if you wanted the mental impairment, I'd include all, but
I would defer, Judge, just to keep it in this juncture as
all right, so I will think about this one tonight, okay?
All right. So
Okay, then manslaughter while operating a motor vehicle under the influence of liquor. So, Ms. Giannetti, you have included in the language, what does it mean to be under the
I
influence of
think that answers one
alcohol?
of my
That
questions.
paragraph that starts after.
I was saying, when I was saying, I don't know if I wonder if they're going to finish these today. It seems like it would be kind of unlikely to me. I think we just got our first hint at that because Judge Bev just said, I'll think about this one tonight, which means they will not have finalized the jury instructions then, is what it sounds like to me, which means more than likely what's going to happen is when they come in tomorrow, they're going to finalize the jury instructions and then get into closing arguments and then charge the jury with the jury instructions, if that makes sense. That'd be my guess.
To the third element. Yeah.
I'm sorry, Your Honor. Is there a page number? I'm just going through my. 9. I have it, yes.
All
Sorry.
right, so you have included, it means that a person has consumed enough alcohol to reduce their mental clarity, self-control, and reflexes, and thereby left them with a reduced ability to drive safely. Where is that language from?
This particular portion one I thought was from the model instructions. If I'm wrong, then we're fine with the model instructions on this issue.
All right, what does the Commonwealth say?
The Commonwealth's language comes from the model and jury instructions, I believe from the most recent 2024 instruction on intoxication.
And that's not in the Commonwealth's request, correct? That sentence I just read?
On page 5, the third paragraph, it's either a similar sentence or a
Yeah, it's a similar sentence, and I was just having both. It was a person is under the influence of alcohol if they have consumed enough alcohol to reduce their ability to operate a motor vehicle safely by decreasing their judgment, alertness, and ability to respond promptly and effectively to unexpected or emergencies. So we don't need both, Ms. Giannetti.
I agree, Your Honor.
So you had both, so I'm just not going to do that.
We're perfectly fine with that.
Okay. Um, So under the second theory, so the Commonwealth is proposing the theory of the 0.08 or greater. The evidence supports that. I'm going to do that. So in the language from the Commonwealth, the fourth element, now then we talk about wanton and reckless. So for the fourth element, Ms. Giannetti, this is where your language. You have language for 5 that actually belongs in 4, I think. I'm just going to find it. On the foreseeability, I think that belongs under 4. And that's where I'll have it. Okay? Belongs at 4 instead of 5. Do you agree with that, Ms.
I see the language now. Yes, that's fine.
Okay, do you agree with that, Ms. McLaughlin? It belongs under 5?
Yes.
Okay. All right. So I'll keep it. I mean, it belongs under 4. I'll keep it at 4 and not have it at 5 where you put it, Ms. Giannetti, okay? All right. I am going to give the lesser included offense of involuntary manslaughter. So there's additional language that I have found helpful in other cases. When I discuss the language and the cause of death, remember, Ms. Reed caused John O'Keefe's death if her actions directly and substantially set in motion the entire chain of events that produced the death. And then the next sentence is a defendant's act is the cause of death where in a natural and continuous sequence results in death and without which death would not have occurred. Okay, so those 2 sentences I find go better together, Ms. Giannetti. Is there any objection to that?
No, I understand.
Okay, any objection from the Commonwealth? So, Ms. Giannetti, you have in here a police officer's opinion about a driver's sobriety, like that testified to in this case. A police officer didn't testify as to the defendant's sobriety. So, okay, so that paragraph that begins with that, we'll just cross that out.
I think that's fine.
Okay. In this same instruction, I have included in the paragraph, in deciding whether the defendant knew or should have known her conduct created a high degree of likelihood that substantial harm would result to another. Some portion of the sentence that I'm going to think about tonight, I have, you may consider any credible evidence that the defendant suffered from a mental impairment or was affected by her consumption of alcohol. Okay. Any objection from the Commonwealth on that?
No, Your Honor, that was requested by the Commonwealth, if you could consider it.
That's the same
Yep,
thing she already
so that will
referenced.
be in that
Think
last
about it.
paragraph of that offense, Mr.
Wow.
Giannetti. Okay, then the lesser included offense, motor vehicle homicide, felony, OUI, liquor, and negligence. I'm going to give that. So I don't have anything because you didn't, the defense didn't propose any lesser included. So I didn't see anything that was inappropriate about the Commonwealth's instruction, Ms. Giannetti.
Okay.
I've added, I think, one line that a person acts negligently when she fails to use due care. That is, when they act in a way that a reasonable person would not act. This can happen either by doing something that a reasonable person would not do under the circumstances or by failing to do something that a reasonable person would do. It's obviously the law, right?
Right, that's the law of negligence. do understand the law of lesser included and, you know,
Okay.
like, I get that.
All right. Thank you. So leaving the scene of an accident resulting in death. So what the Commonwealth has provided is basically just the six elements with nothing further. They're pretty much 1 and 2 have already been defined for the jury many times at this point. 3, the defendant knowingly collided with John O'Keefe. I think that's self-evident.
Collided.
So, Ms. McLaughlin, why don't we start from here? Why did you
I'm
just give
gonna
me the
clarify
6
something real
elements?
quick.
Your Honor, as you
Oh, Candace. Okay. So have I, oh my God, the Lolly voice. She was having dinner with her son and filling him in and started doing, oh my God, that is hilarious. That is amazing. I love that. I love that. So I just wanted to clarify something. So it was just happened really fast at the very beginning of this where Judge Bev was talking about the lesser includeds or whatever. And it sounded like they were just not going to be given instructions. I think what she was meaning by that is that no one's making any changes to the standard instruction. That's what that sounds like. So I just wanted to clarify that. I was like, wait, they're just not going to give any instructions. It's just, they're not, it sounds like neither party is making a request to change. So remember the way this works, right, is there's your standard jury instructions, like we already heard them reference, that are updated every year for each state, right? The standard jury instructions. So then whenever you have these trials, right, for any trial, then both sides can make any changes or additions to those standard instructions by looking at instructions from years past, looking at case law, what have you. So that's what this is about, because I don't know that it ever would happen ever where a standard instruction is just good to go for any trial. There's always something specific, right? So that's what this is.
suggested, the first 2 have been defined extensively for the jury, and I believe the other 4 prongs are self-evident, so they don't need further instruction.
Yeah.
I think it would be sort of redundant or unnecessary to explain to a juror what failure to provide documentation of registration and things like that does not warrant additional instruction.
Do you think they need to listen to me any longer than necessary, Ms. Tianetti?
We're in complete agreement, maybe for the first time in this.
All right, so we'll just leave it. You've offered 2 pages or 3 pages of definitions, so we won't do that.
It's gone.
That's
Okay.
funny to hear her laugh, man. We knew she
All
had
right. Ms. McLaughlin, the use of a dangerous weapon, a motor vehicle, I agree that's an appropriate statement of the law.
dangerous weapon. What?
Tell me about your request to have that.
Yeah.
Your Honor, the request goes to the defendant's state of mind. Also, it
I
would
would have
go
a problem
to
with that.
any
I would
intent
have
or any understanding of the jury of what would be reckless conduct or negligent conduct or intentional conduct. If they understand that the use of a motor vehicle to commit a crime could be a per se dangerous weapon,
Oh, come on,
and
man.
using that to
No.
strike an individual,
I mean, literally,
that could be used in their deliberations,
no.
assessing the defendant's intent or state of mind at the time of the collision.
It seems to make sense, Ms. Tianetti.
My position is it's unnecessary, but I'm going to waive argument beyond that.
Okay. All right. I think it makes sense, and I'll just leave it sort of as a catch-all at the end where it appears on the Commonwealth's request. All right. So that's basically it. The longest part maybe is the general instructions in the beginning.
Well, why are they not
Anything
using a drinking
specific
glass?
from the Commonwealth that I did not include?
If the car is a dangerous
Do you want
weapon,
to
what
give
about the
conscious
drinking
of
glass?
guilt instruction?
Oh, I'll hear you on that. I don't, but you can try and convince me if you want.
Your Honor, the Commonwealth would put forth that there's been sufficient evidence that the defendant has engaged in actions that go to a consciousness of guilt.
Wow.
There's an inference that the
You know they're
defendant
referencing
deleted
her
portions of the
freaking-
ring video, a narrow area of ring video portion, ring videos that
Oh.
are missing. They begin with Mike Camerano picking up his daughter at 11 a.m. They resume at 5:07 when the defendant backs her vehicle into John O'Keefe's.
This is some
And
audacity,
there's a
right?
period missing where the defendant shows the broken taillight to Jennifer McCabe and Carrie Roberts, and then the video resumes again when
Okay.
the victim
All right.
gets-
Let's pause this for a
But
second. I'm
not
sorry.
only the
I think she doesn't know what consciousness of guilt means. Typically, that's people trying to cover up what they did, and that shows their consciousness of guilt, right? So, for example, cleaning up after a crime, or running away and changing your name, or I mean, my God, there was tons for Alex Murdaugh, right? Like the way he knew what time to say he wasn't at the house, shit like that. I don't think she understands what it means based on what I'm hearing her say.
missing ring videos, but also the defendant's behavior. What began as testified to from the Dighton police officer, the defendant's father called the Dighton Police Department and requested a ride to the Good Samaritan Hospital due to the weather conditions. He then drove
this is
himself to
opposite
Brooklyn
of consciousness of
pick up
guilt.
the defendant and perhaps bring her
This
home.
is hilarious.
What they do in the middle of a blizzard is now Dighton to Brockton is half a distance. Then they traveled further all the way back to Canton to retrieve the murder weapon, along with the defendant's brother.
The murder weapon. You're fucking kidding me. Okay. Do you guys remember in the recap last night when we heard Trooper Proctor say something about driving there and back, and we were like, literally, I might have timestamped it, but we were all like, what the hell is he talking about? What? And then I think Super Planner Girl suggested something like that she needed something about her dad and her brother, but it was like so far afield that I couldn't even figure out what was trying to be hinted at there or whatever. This is what she's saying now. She's trying to use this as consciousness of guilt. And that the only time that came in the freaking trial was from Trooper Proctor on the stand. That's it. Let's listen to this again. This is insane. This is insane. Wow. Holy shit. I might hate her more than Molly right now.
Canton to retrieve the murder weapon, along with the defendant's brother.
I'm sorry,
They all meet-
you guys, to retrieve the murder weapon. She's referring to Karen's car, to go get her car, which is her only mode of transportation. And how else was she, like DSN was saying, how else was she supposed to get the car to them? I'm backing it up a little bit further. This is insane.
Defendant's brother. They all meet at the victim's residence to remove the murder vehicle and bring it all the way down to Dighton, Massachusetts. That would go to concealing evidence and intentional.
Insane.
There's also evidence of the defendant's statements going to her consciousness of guilt within hours after
She's
John's death.
confused.
The victim's sister-in-law calls the defendant, reaches out, wants to make sure she's okay. The defendant says to her, "I only have to remember the bad times. You'll likely never hear from me again." Erin O'Keefe testified that the defendant, she tells the
Yeah, but
defendant,
she was
"Of course
getting
we are, we're
section
friends."
12. Oh my
Never heard from
God.
the defendant
I
since. So
cannot.
I think that goes to the defendant's state of mind.
She was
in the
getting
hours
section
after death.
12.
But in
We
addition to the ring
broke
video, I
that
think there's
down in
strong
one of the
evidence of
recaps.
consciousness of guilt to move the murder vehicle within hours of John's death.
Ms. Giannetti?
Well, first of all, with regard to the ring video, Trooper Guarino, who was certainly no friend of the defense in this case, testified that there was zero evidence that Karen Reed had access or had access anything on that computer, and the Commonwealth utterly failed to prove that she had any access to delete anything. So I would say that that is a red herring. This is the one case.
That was put nicely. I would have said lie.
Where there's much more consciousness of guilt evidence with regard to the Commonwealth's own witnesses than there is with regard to
Absolutely.
the defense.
Yes. Yes. Preach.
And with regard to the other arguments, I'm having trouble following.
So the moving the car extra distance during a blizzard, that part of the argument that the Commonwealth made.
That's insane.
I mean, the evidence was that my client maintained a residence in Mansfield. She didn't live at One Meadow. She spent time there. So, to say that moving her car to her own home, where the police later found it because she was there and picked up the phone and said that the police were coming and she stayed there and they were able to seize the car, that does not rise to the level of consciousness of guilt.
Okay.
The defendant actually moved her vehicle to her parents' residence, so that indictment, not her residence in Mansfield, which would further support an inference that she was concealing evidence.
But, well, even if it's her parents' house, Your Honor, again, if she's no longer dating John O'Keefe because he's passed away, then, it makes sense for her to have her vehicle at her parents' house or her own house, because it does not rise to the level of consciousness of guilt.
nor does she stay at the home of her boyfriend to grieve with the family who just lost the job. She quickly comes back to the house, brings her
This
family
is insane.
members, goes upstairs. for about
She's
20
not
minutes
required.
by herself
Holy
with her
fuck.
father, and quickly leaves the
I am
residence.
sorry. I'm gonna lose my mind, you guys. I'm gonna lose my mind. I'm gonna lose my mind. I'm trying to pause. I can't even remember how. I'm gonna lose my mind. She's saying that because she didn't stay at the house. That further than. Oh boy, she's worse than all. This is insane. That's consciousness of guilt. You're joking. Dude, I'm gonna back it up again. Although I don't really know if. Oh my God, this is another level. This is another level.
Back to the house, brings her family members, goes upstairs for about 20 minutes by herself with her father, and quickly leaves the residence.
There's no evidence that she did anything upstairs or that she had access or the ability to change anything.
Okay, it's a little bit more robust argument than I expected from the Commonwealth, so I'm going to think about this. I'll let you know before closing argument tomorrow, and if I don't instruct on it, Commonwealth's still able to testify to it. Witness pretrial preparation, that came out on both sides. I'm going to give the second alternative. Okay, Ms. Giannetti, I'll hear you on your instructions.
Wow.
So I believe that we covered the vast majority of it.
I'll give you the opportunity to argue the
Good.
vote
Argue
one,
the fuck out of it, man.
just so you can make a record.
Sure.
That's fucked. That's fucked. Dude. She's not even going to be willing to listen. And that is insane.
I'll find your page.
No.
Okay, so yeah, I mean, with regards to the voting evidence
I mean-
for instruction, Your Honor, having done this for as long as I have, it's requested a lot and not given, a large percentage of the time. And I do recognize that the court has discretion to give it or not give it, and that we also can argue this in closing argument.
Right.
But, I think that if there's any case where a voting instruction should be given, it's this one. We start with the conflict of interest that existed at the start of this case.
Yeah.
The fact that Michael Proctor was allowed to not
Yeah.
only continue with the case, but to be the lead investigator or police officer during the whole pendency of the case, despite his obvious conflict of interest with the Albert family. We then move to the fact that, he never, as a lead investigator,
I wish we could hear him
went into the house at 34 Fairview. He never looked around. He never checked for any signs of struggle. He never checked out the basement. He never looked for a weapon that could have been used to do the damage that was done to the back of John O'Keefe's head. He never once asked about Chloe, the German Shepherd, despite the obvious injuries to John O'Keefe's arm. With regard to the witnesses, Your Honor, witnesses were interviewed in a very relaxed manner at their own homes. There was testimony that they were interviewed
Insane.
together, that they were not separated out on numerous occasions. Brian Albert, Paul Albert, John McCabe, Matt McCabe, all interviewed en masse. Later, everybody in that group, except for Nicole Albert, was also interviewed at the same time. Chris and Giuliano were interviewed together. And then we have all this, evidence, the way it was handled, or I should say mishandled. Starting with the leaf blowers and the soul cups and things being.
Yeah, this doesn't even need to be said. Why are we even?
Garages not being properly handled, and the fact that there are no chain of custody laws for the
Right.
evidence before March of 2022. So I just highlight those, Your Honor, as examples. I believe there's more.
We'd be here all day if you looked at them all.
Okay, so you satisfied you've made a complete record on this?
Fuck you, Bev, dude.
All right, but I did include some specific bias language that I read to you early on that
Dude,
sort of
I
ties into
cannot
this.
with her.
Okay, so nothing else?
I mean, I don't think there's any way, I don't think there's any possibility that she'll be found guilty. Not even a 0.00001% chance. I know we never know until we hear the verdict, but that's just my opinion. However, should that happen, the appellate issues are endless, so she'll be fine. But still, it still just pisses me off because, Did you hear her? She was like, are you satisfied that you've made your record? She's not even listening to what he's fucking saying. I don't understand. But you know what? Maybe they'll come for her with the federal investigation. I hope so. Get her off the
I have a
bench.
question. The defendant requested a missing witness instruction.
Yeah, you're not.
I've withdrawn that. That was crafted as the trial was ongoing. I didn't know if we were going to have that or
Yeah.
not.
Thank you for bringing that up, Ms.
But I
McLaughlin.
agree that there's.
Oh my God.
Okay. All right. So I will see you tomorrow morning.
Question already said, and I haven't tried this book before, I don't think. Do you typically send a copy of your instructions to counsel prior to?
If I have it finished, I expect I'll be up late tonight and won't have it finished in time for you tomorrow. I do give 2, maybe 3 copies to the jury afterwards.
There was some question as to the use of chalks for closing argument.
Who is that?
Permit the use of chalks for closing argument.
So can we focus on this? So does the defense intend to use chalks?
I'm going to defer to my co-counsel on that.
2
What do you intend to use?
photographs of the vehicle and photographs of the taillight. So 2 side-by-side photographs of the taillight that are in
Who
evidence.
was that talking?
And photographs of the vehicle, still shots of the vehicle that are in evidence.
Okay. Okay.
And that's the extent of it for me.
Okay. Commonwealth have any objection?
No, but the Commonwealth also intends to use chalks.
What do you intend to use?
Also side-by-side photographs and video, but also a timeline that summarizes text messages and voicemails and significant events
timeline.
from January 28th through January 29th.
That'll be interesting.
Okay.
Their timeline is such a fucking mess. I guess that's why she said
Any-
it's gonna be.
I'd like to see that. in a-
Sure, you should both exchange them.
Okay.
Okay.
It sounds like she said it's just going to be text messages and voicemails, which makes sense, right? Because otherwise it would be a disaster. Although I feel like the timeline with that is still not even solid. I have no idea what chalks are. I've literally never heard that before. I don't know if that's just like a term specific to Massachusetts. Very interesting. I've literally never heard of that. Usually, I mean, it sounds like they're saying it in reference to like a demonstrative, but like usually they call it that, where it's like, you know, a PowerPoint presentation type thing. So we shall see what the hell chalks are. And it sounds, I mean, as per usual, she's just trying to get off the bench. I've literally never seen jury instructions take this little time. This is insane. But like, I guess she shut down the defense's arguments multiple times to save time, right? She's like, yep, you made your record. Let's go. Let's get out of here. I'll think about it overnight. So what I'm wondering is she just going to come in the morning and be like, yep, here's my decision. Bam, done. Or are they going to be arguing it more? Because my expectation is that there's more to argue, because she's like, I'm going to have to think about it, right? But again, knowing her and the fact that she's not actually fair and doesn't do things the way other judges do, I guess I couldn't really say that it would be all that surprising if she's just like, yep, I just made my decision. We're done. I mean, to me, it's like the issues are, there's just so many. And like that would be just another whole set of issues. Because usually judges care about what is happening and like what, you know, they want a fair trial and they want to do their job correctly. And I mean, if I'm sound harsh, you know what? I've had it. This is on another level, in my opinion. Because this is super fucking important. She's like not even taking it seriously. That's how this reads to me. Like, she laughed that 1 second. And I was like, oh, that's funny. She's laughing. But like, other than that, she's been worse than usual, I feel like. So.
Judge, my other question is that at one point during the trial, there was a changing of 2 jurors, their seats, just for purposes of their own comfort. The way I pick alternates is by seat number.
So I'm going to ask you not to pick them by seat number, Jim.
Okay, he's
By
clerk.
juror number, juror card number.
Clerk of court.
They
Okay.
may not remember
He's
what
like the
that
Becky
is.
Hill. That's
No, I have absolutely.
No, they may not.
Okay. They may not know their old juror number?
Their actual 3-digit number.
Right. They may not know that. Do you want me to use it?
No, if they know it, we'll use it. We'll talk about this.
Okay.
when?
Why did you
You're
want to move them in?
fucking
We'll
honor.
talk about this.
Okay.
When?
All right.
You know, when is that done?
He's like, let's talk about it now. This is
At the
Jesus.
at the end of the instruction,
never.
before I give the instruction on be fair, the SJC instruction on be
what do
fair.
you expect to do it? Dude, like that's it. Oh my God, I don't even know what's happening. This is insane. Okay, that's it. So you guys, it just cut off right there. That was it. What is going on? Can we not, hold on. What is happening? Okay, I don't know what is, it looks like it just cut off there. Hold on. Let's see if that's, we all know she wanted to get off the bench. Let's just see if there's anything else. That was crazy.
Before I give the instruction on be fair, the SJC instruction on be fair.
Okay, is there anything else here? Nope, that's it. All right, there you have it, guys. Wow, okay, well, hold on.
Before I give the instruction on.
Let's just do this. I was not ready for it to end like that. I was still like processing what's going on right now because this is so crazy. Wow. So she's like, we'll talk about it. He's like, well, that's what we're doing now. Like, that's their clerk of court. You guys, let's hear that again. That is insane. Listen to how she treats the clerk of court who just wants to have this little detail. This is insane. It would take 2 seconds and she will not even do it. This is crazy.
On this. So does the defense intend to use chalks?
Okay, let me go forward a little bit. We heard about the stupid
What do you
chalk.
intend to use?
There they are. This guy, he wants to be heard. This dude wants,
Commonwealth have any objection?
it's important, dude.
No, but the Commonwealth also intends to use.
Let me just say, so this dude right here is the dude who's speaking, who has a really loud voice. I guess there's a microphone there. This is important. His job, he's the clerk of court. He's the Becky Hill of this trial. He wants to make sure he knows how the jurors are going to be numbered, and she will not even give him the fucking time of day. Let's just listen again.
January 28th through January 29th.
Okay. Any,
The request is I'd like to see that.
sure, you should both exchange them, okay?
Judge, my other question is that at one point during the trial, there was a changing of two jurors, their seats, just for purposes of their own comfort.
God forbid anyone
The
care
way I
about doing
pick
their job correctly.
alternates is by seat number.
So I'm going to ask you not to pick them by seat number, Jim, by juror number, juror card number. They
Okay.
may not remember what that is.
No, I have
No,
absolutely.
they may not.
Okay. They may not know their old juror number?
Their actual 3-digit number.
Right. They may not know that. Do you want me to use it?
No, if they know it, we'll use it. We'll talk about this.
Okay.
When?
All right. Why did you want to move them into? We'll talk about this.
Okay.
When? This is insane. She's not finalized the jury instructions. She's not even answering that dude's question about just simple jury numbers. And then she's planning on coming in and going into closing arguments without setting any time aside for this. Like, this is insane. Wow. That poor clerk of court. I mean, really, look at, you know what? Like, it's crazy because we hear this from everybody that, like, these clerks of court are, like, so vital, right? And they do everything. And they're you know, we hear it all the time of, like, if anyone says anything to, like even remotely could be construed as, like, mistreating or disrespectful to, like, the court staff, it's like, yeah, you're done. And here's the judge. I'm really curious what like EDB is going to say about this and others, because I am very surprised. I mean, I guess I shouldn't be because Judge Bev is but still though, right? Like, that's crazy. Like, that's your court staff, man. Like, he's just trying to do his job. Like, what? You can't take 1 minute to answer his question about the juror numbers so he can feel confident when he comes in tomorrow. I'm at a loss for words right now on this one, guy, I think. So, wow. So I don't know what to say. Like, I don't know what to expect tomorrow because it sounds like she's not actually accomplished much here. This was brief and she just kind of seemed to say we'll do it all later. So I don't know that they'll be able to start with closing arguments first thing tomorrow morning because they haven't finalized this shit. So we'll see. Maybe they'll finalize it between 9 and 9:30, and then at 9:30, right on the dot, she's like, that's it, we're done. We're going to start closing arguments regardless. So we'll see. But I'm going to be there to cover it. So assuming court starts on time, right? But I'll be there in the morning watching for, you know, it's usually supposed to be 9 o'clock, but it never is. But I think I've got it scheduled for 9 o'clock, but if they're delayed, then I'll push it back or whatever until when they finally, because we don't need to sit there and watch the OnlyFans for 15 minutes. So, all right, what a day. This has been a crazy day. There's been a lot of crazy days in this trial. This might be one of the craziest so far because it was like a fucking whirlwind, right? But that's it. And I mean, the jury will get, I would imagine they'll be able to start deliberations probably like maybe after lunch. What if we have a verdict tomorrow? What if that's it? Like this trial took forever and then what if we have a verdict tomorrow? I hope so because I'll be available to cover it. And that'll be my first time covering a verdict live. Oh my God. Sorry, that just dawned on me. And I can't even believe I just said that. I've never covered a verdict live. And that's insane to me. I never thought I'd be doing that. But like, wow. I hope y'all will be able to join me for that because that's going to be a huge moment. We've watched this trial together, you guys, for 9 weeks now, day in, day out. Live trial coverage, recaps, and we might even get a verdict tomorrow. And then it's gonna be over. So I'll do the things. I'll do the verdict, and then if they do any, press conferences after the fact and shit like that, I'll cover that. I'll stay on as long as I can. We haven't heard closing arguments yet, but I think you guys could probably guess my opinion is that it'll be a pretty quick verdict for not guilty. That's my, if there's any delay, here's what I think it would be. I think it would be that the jury has not gotten to talk to each other this whole time. And the first things out of their mouth, if I had to guess, are going to be, you guys, the solo cups or something like that, right? Like they haven't had a chance to just talk about the insanity of, like, if they want to just review the insanity just to I remember we heard something similar with Chad Daybell from the jurors that like they hadn't gotten a chance to talk and the first thing they wanted to do was be like, oh my God, the storm and the zombies, right? Just to get it off their chest of how crazy it was. I could see something similar here of like them just trying to be like, oh my God, we haven't been able to say anything about how insane this was and like Trooper Proctor and all this stuff. So, but still, I mean, I don't know, maybe an hour or two of that and then verdict, but we'll see. I'm excited. Holy shit. Okay, well, there you go. There you have it. So I'll see you guys bright and early in the morning. Lolly made it extremely painful. Judge Bev made it painful. But the defense made it tolerable and made it worth watching. Without a doubt, without even a question. And I'm excited to see what will happen next, right? Because there's going to be civil lawsuits, I'm sure. There's going to be civil lawsuits. We've still got the federal investigation. I think that it's time for justice for the victim and the defendant to finally happen. And hopefully we will see that tomorrow. So, all right, y'all. Y'all are the best. Thanks for being a squirrel. And I'm going to roll the outro. See you tomorrow.